Your property is in violation. You have 14 days to comply, or we will take action. She said it the way people say things they have rehearsed in a mirror, clipped, declarative, final. Her name was Renata Collier, and she was the president of the Ridgeline Estates Homeowners Association, standing at the edge of my shooting range berm on a Tuesday morning in late October with a clipboard and a blazer that had no business being within 50 miles of a working piece of land like this one. The air smelled of gunpowder residue and wet clay and the particular cold that comes off a Tennessee ridge when the leaves are mostly down and the sky has gone the color of old pewter. I had been running targets that morning. I set down the rifle very carefully, and I looked at her. She had no idea. That is the part I want you to understand before anything else. She had no idea that the berm she was standing beside, the range behind it, the access road her white Escalade had driven in on, the fence line she was citing as a violation, all of it was sitting on land I owned outright, land that had been in my family for 4 generations, land with a deed so clean and so old that the county recorder's office kept a photocopy in a separate archive for historical reference. She had no idea about any of that, and I did not tell her. Not yet. Drop a comment and tell me where you're from, and if something like this has ever happened to you, I want to hear it. I was not angry. I want to be clear about that. I looked at Renata Collier standing on my land in her blazer, holding her clipboard with its printed violation notice, and what I felt was something closer to recognition. I had seen this before. Not this woman, not this specific performance of authority, but the shape of it. The assumption that a title and a document and a confident posture constitute jurisdiction. They do not. The record does. I thanked her for coming. She did not know what to do with that. My name is Callum Voss. I am 61 years old, and I have lived on this property, or near enough to it, for most of my life. I was a structural engineer for 32 years, which means I spent 3 decades reading documents that had to be exactly right or people died. I retired to this land not because I had run out of things to do, but because the land itself had always been the thing I was working toward. And I kept files, organized, labeled, never thrown away, and always exactly where I expected them to be. The shooting range had been there since before I was born. My grandfather, Harlan Voss, built the original berm in 1951 using a borrowed bulldozer and about 400 hours of his own labor. He was a Korean War veteran who believed that accurate shooting was a form of civic responsibility, and he built that range the way he built everything, with the intention that it would outlast him. The berm ran 240 yards along the eastern face of the property, backed by a natural limestone ridge that Harlan had recognized immediately as the best backstop a man could ask for. He set the firing line at 100 yards, then at 50, then at 25, and poured the concrete pads himself. He planted cedar posts along the perimeter and strung wire, and every spring he walked that wire and replaced whatever the winter had taken. The range sat on approximately 11 acres of the total property, which ran to 108 acres in all, deeded in full to the Voss family in a warranty deed recorded with Harlan County in August of 1947. The deed had never been subdivided. It had never been encumbered by any covenant running with the land that included the Ridgeline Estates development. It had simply sat there in a manila folder in my filing cabinet, waiting to be relevant. Harlan left the property to my father, Douglas Voss, in 1979, and my father left it to me in 2004. Between those 2 events, the land had been maintained, taxed, and used continuously by our family. The range had been used by my father and his brothers, by me and my cousins, and for the last 9 years, by an arrangement I will come to shortly, by the Harlan County Sheriff's Department. That arrangement was the detail Renata Collier had not done her homework on. That was the detail that would eventually cost her board considerably more than the $375 fine printed on their violation notice. The Ridgeline Estates development had been platted in 2009, during the last gasp of a real estate cycle that had no business being optimistic. A developer named Whitmore had purchased 42 acres on the western edge of my property's boundary, land that had once been a hayfield belonging to a neighboring family named Pruitt, who sold when the price was right and the farming had gotten hard. Whitmore built 31 houses, paved 2 cul-de-sacs, planted a sign with a mountain silhouette on it, and formed a homeowners association before the last house had a certificate of occupancy. The HOA's recorded covenants, conditions, and restrictions, the CC&Rs, covered the 42 acres of the Ridgeline Estates plat explicitly. The document named the parcel boundaries by meets and bounds, referenced the recorded plat map, and stated in Section 1, Paragraph 2 that the covenants applied to all lots within the recorded subdivision plat of Ridgeline Estates, as filed with Harlan County on March 14, 2009. My land was not within that plat. My land had never been within that plat. The boundary between Ridgeline Estates and the Voss property was a surveyed line that had existed since 1947, and it had not moved. None of that had apparently been explained to Renata Collier. She had taken over as HOA board president 18 months before she appeared at my shooting range, and by every account I had heard from my neighbor, Eldon Marsh, who lived on the western edge of Ridgeline and had a front-row seat to the board's operations. She had arrived with the conviction that the HOA's authority extended to anything she could see from the subdivision's roads. Eldon was a retired surveyor, which made him a useful ally, and a man with very little patience for boundary disputes conducted by people who had never read a plat map. He had called me twice in the months before Collier's visit to report that the board had been discussing the shooting range at their monthly meetings, citing noise complaints from 2 residents whose houses backed up toward the eastern edge of Ridgeline, closest to my property line. I had not been invited to those meetings. My land was not in their jurisdiction. The first official communication I received from Ridgeline Estates HOA was the violation notice Collier handed me that October morning, citing 3 specific violations: unauthorized discharge of firearms within the community, failure to maintain fencing consistent with community aesthetic standards, and operation of a commercial shooting facility without board approval. I read all 3 lines carefully, standing at the firing line with the smell of spent brass still in the air. The first violation assumed my property was within their community. It was not. The second cited my fence, the cedar post wire fence that Harlan had built in 1951, that my father had maintained, and that I had rebuilt along the original line in 2017 using cedar posts I had milled myself from trees on the property. The fence was entirely on my land. There was nothing in any recorded document that gave the Ridgeline Estates HOA any authority over a fence on land that predated their development by 62 years. The third violation was the one that interested me most. They had called it a commercial facility. The word commercial is a legal conclusion, not a description, and the reason they had reached it, as Eldon later confirmed from a conversation overheard at a board meeting, was that someone had seen a county sheriff's vehicle parked at my range on multiple occasions and assumed I was operating a paid training facility. That assumption was wrong in its specifics, but pointed in an interesting direction, and the specific truth of it was something I had documented very carefully. 9 years earlier, I had entered into a formal lease agreement with the Harlan County Sheriff's Department, signed by the sitting sheriff, recorded with the county, and renewed annually, granting the department the right to use the Voss range for quarterly firearms qualification training and periodic tactical exercises. The lease was valid. The department paid a nominal annual fee, and the arrangement had been by every measure unremarkable, except that it was a recorded legal instrument. And Renata Collier had cited the visible evidence of that instrument as the basis for one of her violation claims. She had, without knowing it, handed me the thread that would unravel everything she thought she had built. I folded the violation notice along its original crease and put it in my jacket pocket. Then I went inside and called my attorney, a woman named Patricia Okafor, who had handled the lease drafting 9 years ago and kept copies of every recorded document associated with this property in her own files. I told her what had happened. She was quiet for a moment, then said, "Send me the notice." I did. She called back the following morning and said 4 words before anything else. "They have no jurisdiction." I knew that, but I wanted the record to say it. Patricia pulled the Ridgeline Estates CC and Rs from the county recorder's office within 2 days. She pulled the recorded plat map, the 1947 deed, the 1979 transfer, and the 2004 transfer. She laid them side by side and confirmed what I had known since the morning Collier handed me that envelope. The Voss property was not within, adjacent to in any legally encumbered sense, or subject to any covenant recorded by Ridgeline Estates HOA. The plat boundary was clear. The deeds were clean. The CC&Rs contained no language extending authority beyond the recorded plat, and the recorded plat did not include a single square foot of the Voss parcel. Patricia also pulled the recorded lease between the Voss family and the Harlan County Sheriff's Department. It was a public record filed with the county recorder's office at execution, naming the parcel, describing the permitted use, stating the annual consideration, and bearing the signatures of the sitting sheriff and of my own name on the renewal page. She sent me the full packet by certified mail. I made coffee before opening it. I spread the documents out in the order she had organized them and read each one the way I had learned to read structural drawings, not for what they said, but for what they required. What they required, taken together, was simple. The HOA had no legal foundation for any of the 3 violations they had cited. The first was a jurisdictional error. The second was a jurisdictional error applied to a structure that predated the HOA's existence by 6 decades. The third was a mischaracterization of a lawfully recorded government lease as a commercial operation. I did not respond to the violation notice within the 14 days. I let the deadline pass. Not out of defiance, out of process. Patricia had advised me to wait for their next move, because their next move would tell us how far they intended to push a claim they could not legally support. She was right about what came next. The fence appeared on a Thursday morning in early November, 3 days after the violation deadline expired. I heard the equipment before I saw it. The low diesel knock of a skid steer, the sound of post-hole augering. I walked out to the eastern boundary and found a crew of 4 men installing chain link along what they had apparently been told was the HOA's boundary line. The line they were fencing was not the HOA's boundary. It was approximately 30 feet inside my property, running parallel to and inside the cedar post fence that had stood there since 1951. They were fencing off a strip of my land, including a portion of the shooting range berm, on the authority of a boundary claim the HOA had no survey to support. I stood at the cedar fence and watched them work. I did not speak to the crew. I took photographs with a timestamp, the equipment, the crew, the new fence posts going into the ground, their position relative to the existing cedar fence, and the GPS coordinates I recorded on my phone. Then I went inside and called Patricia. She said, "They just made this considerably worse for themselves." She was exactly right, because the fence was not just a trespass. It was a physical act of enclosure on land leased in part to the Harlan County Sheriff's Department, which had a training exercise scheduled for the following week. I noted the date, I filed the photographs, and I wrote one word on the legal pad I kept beside the kitchen table. The same pad where I had been logging every communication since October. The word was trespass. Patricia filed the trespass complaint with the Harlan County Circuit Court on a Wednesday, and by Friday she had also sent a certified letter to Ridgeline Estates HOA, addressed to Collier as board president and to the HOA's registered agent. The letter notified them that the November 7th fence installation had occurred on private property outside the HOA's jurisdiction, demanded removal within 30 days, and cited Tennessee Code, annotated Section 29-30-101 governing trespass to real property. It noted that the physical enclosure of land subject to a recorded government lease raised additional considerations the board would want to discuss with its own counsel before proceeding further. The letter cited the 1947 warranty deed by instrument number and the recorded plat boundary by book and page. I did not call Renata Collier. I went out to the range on the Saturday after the letter was sent, walked the berm, checked the cedar posts, and took another full set of photographs. The new chain link fence was still there, its galvanized posts bright and clean against the brown November grass, running its 30-foot intrusion across the eastern edge of my property. I photographed it from 6 angles, noted the GPS coordinates of each corner post, and filed everything in a folder I labeled in black marker on the tab, simply as November Fence. Eldon Marsh called me that evening. He had attended the Ridgeline Estates board meeting the night before as a resident observer, which he was entitled to do under the HOA's own bylaws. He reported that Collier had read Patricia's certified letter aloud to the board and that the room had gone quiet in the way rooms go quiet when people begin to understand they have stepped onto ground less solid than they believed. One board member, a man named Forsyth, who worked as a commercial insurance adjuster, had asked Collier directly whether the HOA had obtained a survey before authorizing the fence installation. Collier said the boundary was clear from the plat map. Forsyth asked whether she had compared the plat map to the adjacent property's recorded legal description. She had not answered him directly. Eldon said she had moved on to the next agenda item. Forsyth, Eldon told me, had stayed after the meeting and asked to see the plat map himself. I noted that. I added a second word beneath trespass on the legal pad. The second word was cracks. The survey Patricia commissioned came back in the second week of November, conducted by a licensed land surveyor named Gerald Pruitt, who had been surveying Harlan County for 31 years. He arrived on a Tuesday morning with his equipment and his assistant and spent the better part of a day establishing the boundary from the original 1947 monuments. He found 2 of the original iron pins still in the ground, corroded to the color of old blood, but precisely where the 1947 deed said they would be. He set new monuments at the corners, photographed the original pins in place, and produced a survey report establishing the boundary line to a precision of plus or minus 1/10 of a foot. The chain-link fence was, at its closest point, 28 feet and 4 inches inside the Voss property line. At its farthest, 32 feet and 9 inches. The entire fence, every post, every foot of chain link, every tension bar and top rail was on my land. Not 1 inch of it was on the Ridgeline Estates side of the boundary. Gerald Pruitt's report was filed with the county recorder's office within 48 hours. It was now part of the permanent land record of Harlan County, Tennessee, indexed to the Voss parcel, available to anyone willing to pull the file. Patricia filed an amended complaint with the Circuit Court incorporating the survey findings, attaching Gerald Pruitt's report as Exhibit C, and formally requesting a temporary restraining order prohibiting any further physical alteration of the Voss parcel pending resolution. The motion also noted, for the first time in a filed document, the existence of the recorded lease with the Harlan County Sheriff's Department and observed that the HOA's fence impeded access to a portion of the leased premises. The judge issued the temporary restraining order on a Thursday afternoon. It was served on the HOA's registered agent by 4 o'clock. Patricia called me when it was done. She said, "The TRO is in place. They cannot touch that property until the hearing." I thanked her. She said, "The lease mention in the filing is going to get attention. Be ready for a phone call." I told her I was always ready for phone calls. She laughed, a dry, brief sound, the laugh of someone who had been reading documents for 20 years and had learned to find a particular satisfaction in the moment when the record begins to speak for itself. The phone call came the next morning. It was not from Renata Collier. It was from a man who identified himself as Dale Whitfield, the attorney retained by Ridgeline Estates HOA. He was polite, measured, and careful in the way attorneys are careful when they have just read a filing that introduced a fact they did not previously know. He said the board had authorized him to propose removal of the fence in exchange for a mutual release of claims. I told him I would pass the proposal to my attorney. I thanked him for calling. I called Patricia immediately. She was quiet for a moment, then said, "They won out. The lease mention scared them." I asked what she recommended. She said, "Don't accept a mutual release. You have a trespass claim, a valid survey, a TRO, and a recorded government lease their fence is interfering with. A mutual release gives up all of that for a fence removal they are already legally obligated to perform. Let's go to the hearing." I told her to proceed. That was the posture I held from that point forward. Not aggressive, not retaliatory, simply unwilling to release a legitimate claim in exchange for the performance of an obligation that already existed. My grandfather Harlan had built that berm with borrowed equipment and 400 hours of his own labor. My father Douglas had maintained it through 30 years of Tennessee winters. I had rebuilt the cedar fence line with timber I had cut and milled on the property itself. None of that history required me to accept a quiet settlement that left the record incomplete. Eldon called again in the third week of November. Forsyth had retained his own attorney for a personal consultation and had been asking questions about board member liability in trespass actions. Those questions had not been warmly received by Collier. The board meeting that week had been tense in the specific way that meetings become tense when the people in the room begin to understand they are not all in the same position. I wrote Forsyth's name on the legal pad with a small notation beside it, separating. The hearing was set for the second week of December. Patricia requested the HOA's board minutes for the 18 months of Collier's presidency, the correspondence authorizing the fence installation, any survey or boundary analysis the board had relied upon, and the identity and license information of the contractor. The HOA's attorney produced the board minutes and the fence authorization correspondence. He did not produce a survey, because there was no survey. The board had authorized the fence installation based on Collier's representation of the boundary, and Collier's representation had been based on her reading of the Ridgeline Estates plat map, a document that showed the HOA's own property but made no representation whatsoever about the legal description of the adjacent Voss parcel. That absence, the absence of any survey, any title search, any comparison of legal descriptions before the fence went into the ground, was the document that mattered most to Patricia. In a trespass action, the failure to conduct professional verification before a physical act speaks to the character of the act. It is the difference between an error of measurement and an error of process. Patricia organized the full evidentiary packet over 3 weeks: the 1947 deed, the 1979 transfer, the 2004 transfer, the Ridgeline Estates plat with the boundary clearly marked, the HOA's CC and Rs with Section 1, Paragraph 2 highlighted, Gerald Pruitt's survey report with encroachment measurements annotated, the board minutes showing the fence authorization, the absence of any survey in the HOA's production, the certified letter with the return receipt, the time-stamped GPS-tagged photographs of the fence installation, and, filed last, the recorded lease between the Voss family and the Harlan County Sheriff's Department, the legal description of the leased premises, the permitted use, the annual consideration, and the signatures of the sitting sheriff and of my own name on the renewal page. She sent me the complete packet in a banker's box. I went through it the way I had gone through every document in this process. Methodically, in order, reading each page, not for what it said, but for what it required. What it required was a hearing. What it would produce at that hearing was a record. The box sat on the corner of the kitchen table for the 2 weeks before the December date, and every morning when I made coffee, I looked at it the way my grandfather Harlan had looked at the limestone ridge behind the berm, as something that had been there all along, doing its work quietly, waiting for the moment when its nature would be demonstrated. The night before the hearing, I walked the range in the cold. The sky was clear, and the temperature had dropped below freezing, and the grass along the berm was stiff and pale under the beam of my flashlight. The cedar posts stood where they had always stood. The new chain-link fence stood where the HOA's crew had put it, its galvanized posts already collecting a thin rime of frost. I walked the line from one end to the other and back, the way my father had walked it, the way Harlan had walked it every spring to check the wire. The land was cold and quiet and entirely itself. I went back inside, set the flashlight on the workbench, and went to bed at a reasonable hour. The work had been done. The documents were in order. There was nothing left to do that night except rest. The record was ready to speak. The Harlan County Circuit Court occupied a building that smelled of old wood and radiator heat and the particular stillness of rooms where consequential things had been decided for a long time. I arrived 20 minutes early, a habit carried from 32 years of project meetings where the man who arrived late had already lost something he did not know he needed. Patricia was already there, at the plaintiff's table. with the banker's box open and the documents arranged in the order she intended to use them. She looked up when I came in and gave me a single nod, the nod of someone who has prepared thoroughly and knows it. Dale Whitfield was at the defense table with a younger associate and a folder that looked thin compared to what Patricia had assembled. Renata Collier sat beside him in a blazer, the color of winter slate, her posture correct, her expression composed in the way that expressions are composed when the person wearing them has not yet fully understood what is about to happen. The judge was Emmett Tate, who had been on the bench for 19 years and who had, according to Patricia, a particular impatience for property disputes that arrived in his courtroom without a survey. He had the survey. Patricia had made certain of that. The hearing opened with Patricia presenting the foundational record, the 1947 warranty deed, the chain of title through 1979 and 2004, the Ridgeline Estates plat with its explicit boundary description, and the HOA's own CC&Rs with Section 1, Paragraph 2 read aloud into the record. She read it slowly and without editorial comment. The covenants, conditions, and restrictions set forth herein shall apply to all lots within the recorded subdivision plat of Ridgeline Estates, as filed with Harlan County on March 14, 2009. She set the document down. She said, "The Voss parcel is not within the recorded subdivision plat of Ridgeline Estates. It has never been within that plat. The boundary was established in 1947 and has not moved." She then presented Gerald Pruitt's survey, walked the court through the encroachment measurements, 28 feet and 4 inches at the closest point, 32 feet and 9 inches at the farthest, and noted that the HOA had produced no survey in discovery, no boundary analysis, no title search of the adjacent parcel prior to authorizing the fence installation. Judge Tate looked at Whitfield. He said, "Counsel, what survey did your client rely upon before installing this fence?" Whitfield said, "Your Honor, the board relied on the recorded plat map of the subdivision." Judge Tate said, "The plat map shows the subdivision's property. It does not show the adjacent parcel's legal description. Did your client obtain a survey of the adjacent parcel?" Whitfield said, "No, Your Honor." Judge Tate made a note. He did not say anything else about it at that moment, but the note was the thing that mattered. I had seen the same gesture in 32 years of engineering reviews, the quiet notation of a fact that would not be forgotten. Patricia then introduced the final exhibit. She had saved it deliberately for this position, not for dramatic effect, though the effect was unavoidable, but because it completed the jurisdictional picture most comprehensively. She placed the recorded lease between the Voss family and the Harlan County Sheriff's Department on the table and read the operative language into the record. The lessor hereby grants to the lessee, the Harlan County Sheriff's Department, the right to use the premises described in Exhibit A, consisting of approximately 11 acres of the Voss parcel in Harlan County, Tennessee, for the purpose of firearms qualification training and tactical exercises, for a term of 1 year renewable annually in consideration of an annual payment of $600, receipt of which is hereby acknowledged. She looked up from the document. She said, "This lease is currently in its 9th renewal year. It is a valid, recorded instrument. The fence installed by the HOA on November 7th physically enclosed a portion of the leased premises, impeding the Sheriff's Department's access to land it holds under a recorded government lease." Whitfield's associate leaned toward him and said something very quietly. Whitfield's expression changed in the way expressions change when a fact arrives that reorganizes everything around it. Renata Collier sat very still. I watched her from my seat behind the plaintiff's table and thought of the morning she had stood at the edge of the berm in her blazer and handed me the violation notice, and I thought that she had not known, on that morning, that the land she was standing on was leased in part to the county's own law enforcement agency, and that the fence her board would authorize 3 weeks later would constitute an interference with a government lease recorded in the same county recorder's office where the HOA's own CC&Rs were filed. She had not done the homework. That was the whole of it. Judge Tate looked at the lease for a long moment. Then he looked at Whitfield. He said, "Counsel, was your client aware of this lease prior to the fence installation?" Whitfield said, "Your Honor, I would need to consult with my client on that question." Judge Tate said, "I'll give you 5 minutes." The 5-minute recess was the quietest 5 minutes of the proceeding. Patricia sat with her hands folded on the table. Whitfield and Collier spoke in low voices at the defense table. After 4 minutes, Whitfield stood and said that his client had not been aware of the lease prior to the fence installation. Judge Tate nodded. He said, "Let's proceed." What proceeded over the next 40 minutes was the methodical collapse of every position the HOA had taken since October. Whitfield argued that the board had acted in good faith based on a reasonable interpretation of the plat boundary. Patricia responded that good faith does not substitute for due diligence in a trespass action, and that the HOA's own CC&Rs contained explicit boundary language that a competent review would have shown did not include the Voss parcel. Whitfield argued that the fence had been installed to address a legitimate noise concern. Patricia noted that the HOA had no authority to address noise concerns by physically enclosing land outside its jurisdiction, and that the appropriate remedy was a recorded noise ordinance complaint with the county, not a fence installed without a survey on private land leased to the sheriff's department. Whitfield did not have a response to that. He said his client was prepared to remove the fence promptly. Patricia said that fence removal was the minimum required outcome and did not address the trespass claim or the costs incurred in establishing the boundary. Judge Tate said he agreed with that assessment. The ruling came in writing 11 days later. Patricia called me when it arrived and read the operative paragraph. The court finds that the fence installed by Ridgeline Estates Homeowners Association on or about November 7th on the parcel owned by Callum Voss constitutes a trespass upon private property outside the jurisdiction of the association's recorded covenants, conditions, and restrictions. The association is ordered to remove the fence within 30 days at its own expense, to restore the affected area to its prior condition, and to pay plaintiffs reasonable attorney's fees and survey costs as set forth in the attached schedule. She paused. She said, "Attorney's fees and survey costs come to $11,420. They have 30 days to pay." I thanked her. She said, "The lease exhibit is what did it. The moment Tate saw that the fence was interfering with the sheriff's department lease, the good faith argument was finished." I already knew that. I had known it since the morning I filed the photographs and wrote one word on the legal pad. The word had been trespass, and the record had said so. The fence came down in the 3rd week of January, removed by the same contractor who had installed it, working in reverse, pulling posts and rolling chain link in the cold morning air while I watched from the cedar line. I did not speak to the crew. I took photographs of the removal the same way I had taken photographs of the installation. Time-stamped, GPS tagged, filed in a folder labeled in black marker on the tab, simply as January removal. When the last post was out of the ground and the last section of chain link was loaded onto the truck, I walked the line from one end to the other and confirmed that the cedar post Harlan had set in 1951, the ones I had rebuilt in 2017 from timber I had milled on the property, were still standing exactly where they had always stood. The ground where the HOA's fence had been was disturbed, the grass torn by the post hole auger and the extraction. I made a note to reseed it in the spring. Forsyth resigned from the HOA board in February. Eldon told me, without particular ceremony, that 2 other board members had declined to stand for re-election, and that Collier had retained her position by default, there being no other candidates willing to take it. I noted that without comment. The board's composition was not my concern. The record was my concern, and the record was now complete. The attorney's fees and survey costs arrived by certified mail on the 28th day of the 30-day payment window. A check from the HOA's operating account made out to Patricia Okafor's firm in the amount of $11,420. I filed the confirmation in the same banker's box that had held the evidentiary packet and put the box on the shelf in my filing room beside the folders going back to 1947. On the first warm morning of March, I walked out to the range. The sky had gone from winter pewter to the pale, tentative blue of early spring, and the air smelled of thawed earth and the faint mineral sharpness of the limestone ridge behind the berm. The cedar posts stood along the perimeter the way they had always stood, the way Harlan had intended them to stand when he strung the first wire in 1951, and the berm itself was unchanged, its face packed and solid, the same natural backstop my grandfather had recognized as the best a man could ask for. The disturbed ground along the eastern edge, where the HOA's fence had been, was already showing the first pale suggestion of new grass pushing through the dark soil. By April, it would be indistinguishable from the rest. I stood at the firing line for a while, in the quiet, and I thought about what the whole sequence had required and what it had produced. It had required patience, organized files, and a willingness to let the record do work that anger could not do. It had produced a court ruling, a vacated trespass, a restored boundary, and $11,420 returned to the party, who had been forced to spend it establishing something that had been true since August of 1947. The land was exactly what the deed said it was. It had always been exactly that. The record had simply been asked to say so out loud. That is the thing I would tell anyone who finds themselves in a version of this situation, which is not as uncommon as it ought to be. When an institution with apparent authority makes a claim against your property, a homeowners association, a municipality, a developer, a neighbor with a confident posture, and a clipboard, the first question is not whether they seem authoritative. The first question is whether their claim has a legal foundation, and the answer to that question is never in the posture. It is never in the blazer or the clipboard or the violation notice with its printed fine. The answer is in the record. It is in the deed, the plat, the survey, the covenant language, the chain of title, the recorded instruments that define what a piece of land is and who holds it and what authority, if any, runs with it. Those documents exist. They are public. They are available to anyone willing to pull the file, and they do not change to accommodate a confident misreading of them. The range was quiet that March morning. The limestone ridge behind the berm was the same color it had been in October when Renata Collier stood at the edge of it in her blazer, and the same color it had been in 1951 when Harlan Voss recognized it as a backstop, and the same color it would be long after both of us were gone. The cedar posts held the wire. The deed held the land. The record held all of it, exactly as it always had. I went back inside and made coffee, and the land was still there when I looked out the window, which was all it had ever needed to be. If you have a land story, a boundary dispute, an HOA that overstepped its authority, or a deed that turned out to matter more than anyone expected, leave it in the comments. These cases are more common than people realize, and I find every one of them worth understanding. If you want to follow along when the next one comes up, the subscribe button is there. And the next case involves a road easement and a gate that someone decided to lock without reading the recorded instrument that governed it.